All right, everybody, welcome to LP Video 3. This is Murphy Alexis Mowry, and I'm with National American University, and we are doing the third video for Legal Environment for Global Organizations. So here we go. Okay, so the situation is that we are going to talk about a breach of contract. So good morning, attendees, fellow classmates, and viewing public. This is my third presentation, and I will explain all the possible remedies an international company might have for a typical breach of sales contract. With everyone here and eager to get started, let's move on to the detailed slides. Okay, so we are going to start out with what is a actual sales contract. So a sales contract must include several elements and a party agreement. So we're talking about a business exchange, let's say for a retail supplier and a store agent or distributor. In the contract, the agreement must include a description of the items that are being purchased from the seller to the buyer. The contract must include the quantity of the item chosen, what color the item is, what size it is, and the style. For instance, a polo shirt, 3/4 sleeve shirt, dress shirt, women's, men's, children. And also, once the item is agreed upon and we have all the particulars, will the seller carry the insurance or will the buyer carry the insurance? That is a very key question of the contract. So that would be a clause that the parties would agree upon. Also, who is responsible for the shipping, crating, receiving, duties, and taxes? Since we are going across international boundaries, the buyer and the seller should designate whether the seller will be responsible for the shipping overseas, whether it will be by air or by sea, who the carrier will be, what type of crate the item will be put in upon the arrival of the items in the country of purchase, who will be receiving it. Will there be a particular transportation company? Will there be a specific agent, a driver? And also what duties and other taxes might be assessed and who would be responsible for paying that and covering the cost. So the agreement should be signed by both parties, and that includes all details and clauses. And this information has been gathered from our textbook, which has been produced by Mr. Richard Schaefer, Mr. Filiberto Augusti, and Mr. Lucien J. DeHoge. So, what can go wrong? Even in the contract negotiations, a lot can go wrong. Negotiations can break down, leaving both parties with broken promises, trust issued, and unfulfilled verbal contracts. In certain areas and in certain jurisdictions, even a verbal contract may be agreed upon and taken into court by either party. So, freight might also be left on the docks due to negligence. Questions about the bill of lading. Is the bill of lading an actual document? Is it a transferable document? Does the bill of lading contain the correct information describing the contents? There are also the question of unpaid storage fees. Certain harbors, certain ports have warehouses. They have facilities where things are stored or left or abandoned. And those companies want to collect on the fees of the items that are left behind. Freight might also have extra duties or taxes that are to be paid A customs official might need to inspect the items, and therefore a duty is placed upon those items. Also, there is the amount of human error. Wrong items might be shipped in the correct boxes. We as people are imperfect. We make mistakes all the time, which includes the possibility of a person packing the wrong items into a box and having the label that a buyer wanted placed on that box, but the wrong items being inside. Items may be lost, stolen, or confused in transit. There might be cargo that is strapped on board the deck of a ship. The ship encounters a terrible storm, wind, or rogue waves, and cargo is lost. Therefore, the buyer is out of items. Cargo may show up as damaged, or it may be given to the wrong agent. People are often subject to mistakes and errors, and the right paperwork may go to the wrong person, and the wrong item may go to a totally different area. This is detailed in a wonderful article by Mr. Campbell, and this is where that information has come from. So, choices after a dispute is established. This means that both parties agree there is a problem, they have an argument, there is a dispute, there is a breach of contract. Somebody did not fulfill what duties they agreed or promised to. So the following options are available. There can be a renegotiation and a outside of court restitution. This might be a subfilled order, i.e. the order is completed, but it is completed across 2 shipments. The seller might offer the buyer a discount. I will give you 20% off if you are willing to accept what we have. There might be a substitution. For instance, a company orders 1,000 black shirts and they are able to produce 800 black shirts and 200 blue shirts. If both parties agree, then the seller may take that into account and the buyer may accept the substitution. Also, arbitration is an option. Arbitration would be done through the court. The court would hear both sides. A decision would be made, and if both parties agreed, a signature would be required for the court documents, and monies passed, agreement is counted in the court, and that is sent into records. Mediation might be court ordered, or mediation might be agreed upon by both parties, the buyer and the seller. As part of the contract, mediation may happen in a country of choice. That choice may be up to the buyer or the seller. It would include a person or third party to come in, look at all the documents, do a period of discovery. They listen to the first party's argument. They listen to the second party's argument. The person then makes a formal decision, and that decision is agreed upon and signed into agreement by both. A bench trial might be counted upon by either the buyer or the seller. A court might approve a bench trial if both parties agree to a trial with no jury, i.e. there is no peers that sit in chairs, and there's usually a panel of 3, sometimes 6, sometimes 7 judges who hear the case, and they render a decision. That decision is firm. It's entered into documents. It's entered into the clerk of the court, and everybody walks away. So trial is also an option, whether it be a civil case, a suit, or a formal criminal or accusation, but a trial would include a judge and a jury of the people's peers. So it's important to note that contracts may have subclauses and laws which apply, and a definite or a chosen location for a trial. This is talked about in an article by Mr. Lucas and Ms. Laughlin. So this may change the course of action that each party decides in resolving the breach or dispute. For instance, a company may not want to do a trial in a foreign country due to cost or time constraints or absence of a person or a particular party. So they may choose to go through mediation instead of a lengthy trial. In conclusion, issues may arise from a variety of sources and unpredictable events. Ocean shipping, while it is cost effective, it is subjected to a number of accidents and split-second decisions. Cargo may be shipped via the airlines and be approved for flight, only to be held up in customs or a storage facility. So all of these contracts exist as proof of two parties agreeing to a business exchange. Mr. Stephen Shavel has talked about this in a lovely article written in 2009. Many organizations and people will even disagree on a verbal contract. A verbal contract, in many cases, can be taken into court. This is written about by Mr. Campbell, and his article was published in 2015. So individual needs and desires can change daily, and the most important action is to take a quest for resolution. That way everybody shows up and everybody is happy. The following references have been included. This is from Mr. Campbell, Mr. Locus and Ms. Laughlin, Mr. Schaefer, Mr. Augusti, and Mr. DeHoge, and a wonderful article about breach of contract written by Mr. Stephen Shavel. Thank you for watching. I hope you enjoy. Have a lovely weekend, and we look forward to seeing you soon out there on the net. Bye.